I think it's okay for us to make a start because we have a quorum. We have to elect the chairman, but before that, let me declare any declarations. I'm a member of the Competition Commission, said Mr. Andrew Leung. Okay, so much for declaration. We can now elect the chairman of the subcommittee. Any nominations? I nominate Mr. Dennis Kwok, said Mr. Leung Kwok Hong. Mr. Dennis Kwok, do you accept nomination? I do. Any seconder? I second the nomination. Any other nominations? If not, Mr. Dennis Kwok, please take the chair. We can now invite the administration team to come in.
OK， 咁我哋叫佢解釋咗先，咁就使唔使要 Law Society Bar Association？
其實我呢度都有問，需唔需要下次會請團體咯？你想唔想？
要就算唔請團體都要 invite for submission 啫。
好啊，
因為 Bar 同埋 Law Society。
同埋咧，係咪主席係咪最好將個 discussion 唔好再講翻嗰條 competition rules？ 係，梗係啦。如果唔係，佢哋又會好似上次 panel 咁。講翻佢，即係嗰條以前條標嗰啲嘢。
早晨，早晨咁多位。
Good morning, everybody. First, I'd like to invite Ms. Zhang to walk us through the proposed competition tribunal rules. Yes, can we have an introduction? Yes, Chairman. We have prepared 4 papers for members' information. I think I can go through them one by one in brief, and then I'll see what members might want to ask us. There are 4 papers. Let me go through the first one. This is about the proposed competition tribunal rules and other related rules. As you said, Chairman, this has to do with procedural matters for the future competition tribunal. Let me talk about the background. In 2012, we enacted the competition ordinance, and the administration and the judiciary have been preparing for phased implementation of the ordinance. The judiciary has the responsibility to set up the tribunal, which is a superior court of record established under the CO, and it will be adjudicating cases with regard to contraventions of the competition rules, follow-on private actions, alleged contravention of a conduct rule as defense raised, etc. The relevant ordinance has come into effect in August 2013, and we have also appointed the president and deputy president to the tribunal. Just like other courts, the CTR needs to have its own rules so that it can carry out its business smoothly. And the CO provides that the tribunal may decide its own procedures and may, insofar as it thinks fit, follow the practice and procedure of the CFI in the exercise of its civil jurisdiction. And also, the tribunal is to conduct its proceedings with as much informality as consistent with attaining justice. Later on, I will be introducing another paper, which is a comparison on the differences between the CFI and the CTR. We have also made reference to the RHC, and we'd like to propose the following 4 sets of draft procedural and fees rules. The first one, the Competition Tribunal Rules at Annex A. Number 2, related amendments to the rules of the High Court at Annex B. And C, the Competition Tribunal Fees Rules at Annex C. And the last one, Competition Tribunal Suitors Funds Rules at Annex D. Now, I will be introducing them one by one. The first one, the Competition Tribunal Rules. In formulating the rules, we have made reference to the RHC, but also different types of proceedings that other courts have adopted in similar courts, like the Lands Tribunal. We have also made reference to the rules in different countries, including the UK, Australia, and the European Union. I will also be introducing a paper on the comparison of these jurisdictions. In formulating these 4 sets of rules, we have the following 3 considerations. First, we have made reference to the CFI rules, and where appropriate, we have streamlined the procedures so as to comply with the informality requirement. And for example, we are not going to make use of complicated writs, but we are going to make use of forms. And also, since there may be confidential, commercial, and sensitive information involved, and they may need speedy processing, and that is why we are going to do active case management so that cases will be dealt with where appropriate. And number 3, to minimize legal costs, we like to propose the following 4 measures. Since the tribunal will be taking care of different types of cases, especially those involving claims of small amounts and straightforward cases, we suggest providing the flexibility for the tribunal to dispense with the application of the RHC under certain specific conditions so that there will be fewer procedures to follow. Number 2, for the purpose of informality, we propose the use of relatively simple and general forms to enable parties to set out their grounds of application and response in a succinct manner. In terms of the submission of evidence, we will wait for directions of the tribunal to be made before evidence will be filed. This will also reduce cost. Number 3, we suggest allowing the tribunal to make orders, including any finding, determination, or decision by consent. And number 4, similar to the CFI, we suggest empowering the tribunal to allow consolidation of cases. For example, the cases arise from a common set of facts or laws. Since the tribunal will take care of different types of cases, we have set out the 6 parts to the rules in this paper. And the 6 parts will deal with different things. Parts 1 and 2 will be general rules applicable to all proceedings before the tribunal. Part 3, specific rules applicable to reviews of the Commission's reviewable determinations. Part 4, specific rules applicable to applications in relation to enforcement of commitments, enforcement applications before the tribunal. Part 5, specific rules applicable to follow-on actions when a ruling has already been made that there is a breach. Part 6, specific rules applicable to proceedings transferred from the CFI to the CTR. I will not go into the details of the rules. Those will be in para 28. And now I'd like to talk about revisions to the RHC. First of all, we like to set down the procedures of the different courts, and also if there are appeals taken to the High Court, then there will be rules, and then there will be the rules for fees. That will be in Annex C. Just like other courts, we are going to set down fees so that the users of the tribunal will have to pay relevant fees, say, for example, if they deposit documents with the tribunal. And also, since the operation of the CTR would be very close to the CFI, the fees would also be comparable. We also propose that if the fees at the CTR are the same as those at the HC, we are going to just make reference to those fees. In other words, the actual fees will not be written into the rules of the CTR, but we will direct users of the law to the High Court rules. So there will always be alignment of the fees, and also there will be the minimization of future amendments to the rules. And then Annex D, the suitors' fund fees. Some suitors may have fees in default, and therefore they may have to put deposits with the court. And that is why we are again going to avail ourselves to the RHC, and we have then drafted the suitors' funds rules, say, for example, when interest will have to be paid, and also how audited annual accounts would be put together, etc. Since, again, we are going to operate very much the same as the CFI, we have also made reference to those rules. Now let me talk about consultation. In the past period, with regard to these 4 sets of rules, we have consulted the stakeholders, including the Hong Kong Bar Association, Law Society of Hong Kong, the Commission, and also the Communications Authority. We have held meetings with them to discuss with them in detail these relatively new rules. These rules submitted to LegCo have been agreed to and supported by these stakeholders. And also in the middle of February, we consulted the HALS panel of the LegCo, and the panel agreed that a subcommittee can be formed to examine the draft provisions in detail. This is my introduction to the first paper. At this stage, would members have questions? If not, I like to talk about stakeholders. I remember, indeed, they did not have particular comments to make, and the HALS panel also referred to the views of the Hong Kong Bar and the Law Society. Is that right? We have full support of the Bar Association. Therefore, we did not discuss their views in detail at the panel. Since these rules are new, they asked us for clarification in many places, and we did clarify their doubts, and also now they give us full support. Mr. Abraham Sheikh.
About the questions asked and your replies, can you give us a paper for our reference so that, if necessary, we can ask follow-up questions from the perspective of the public instead of that of the Law Society, a Bar Association? Yes, I can give you that after the meeting. Yes, please give the paper to this subcommittee.
我相信可能阿石議員係想睇咗嗰啲。
Well, but I think Mr. Sheikh would like to read the questions first and to understand their views before we discuss those next time. Well, if necessary, we can write in and ask for follow-up, as you like, Mr. Sheikh, because we'd also like to know the questions asked by the Law Society and their replies. No problem. So, Ms. Zhang, please give us the relevant information. So I think we can move on to scrutinize the rules, but I have 3 more papers. Please walk us through them as well. Be succinct, Ms. Zhang. Well, last time when we reported to the panel, we were asked to prepare the papers. Well, the first information paper is a comparison of the key differences in procedures of the Competition Tribunal and the CFI. I'll just highlight some salient points. As I mentioned just now, the key differences are all set out in Annex A, because for the similarities, we have a provision stating that if there is no such provision specified in the CTR, then one should refer to the High Court rules. So I'll just highlight some key differences. For example, at the start of a legal proceeding, there is a technical requirement at the CFI concerning the use of writs and originating summonses. However, at the tribunal, as informality is our principle, we would use forms instead. On case management, usually the CFI would take a very complex approach. There is case management concerning summonses and also meetings, related meetings. But since we're taking an expeditious approach at the tribunal, we're going to handle the cases expeditiously. We may not need to go through every step in the procedure. For example, if it is in the view of the judge of the tribunal that no summonses are required, there will be flexibility at the tribunal for expeditious handling of cases. And there is also a new procedure called intervention. There is also such a procedure in the CFI, and yet because the cases to be dealt with by the tribunal will be of public interest. For example, a company may be alleged by the Competition Commission of contravening the CO, then I believe the clients of the company or other service providers to this company may be interested in knowing whether such a conduct contravenes the competition ordinance. So we believe that such cases will be of great public interest. And therefore, we need a detailed set of procedures at the tribunal so that any party or the Competition Commission can apply for intervention. For example, a public notice will be published online or in the tribunal so that any intended intervener may apply to intervene at the tribunal, and the judge will consider the grounds of the application, and if the intervention is permitted, the tribunal will give directions for interveners to proceed. The extent of the nature of the intervention will also be directed by the tribunal. On discovery and inspection of documents, because a lot of documents may be of a sensitive nature, the CTR sets out circumstances in which the non-disclosure may be allowed, and the considerations are also set out in the CTR. And apart from information that should not be disclosed to the tribunal, there is information there which should be disclosed to the tribunal, and a streamlined application can be made. For example, litigant A and B may be competitors, and to facilitate the proceeding, the judge may want to read all the documents, and competitor A may not wish the judge to read all the sensitive information. So part of the documents may be obliterated to protect commercially sensitive information, and this is to strike a balance between protecting sensitive information and fairness of proceedings. And for reviews of reviewable determinations, well, this is also a procedure similar to leave application for judicial review at the CFI. So our procedure is largely modeled on that of the CFI. But to streamline the procedure, we also would make some changes. At the CFI, there'll be leave for application for judicial review, and then there'll be another application for review. But at the tribunal, we believe the two documents can be amalgamated. So with leave from the judge, the applicant is no longer required to submit another document for review, as the application for review. So this is the second document setting out the differences between the CTR and the CFI. Legal advisor. Well, at this stage, I have a question related to policy matters which may also be of interest of members, and I'd like to clarify the situation. This is about instigating legal proceedings. Well, as you mentioned, that the tribunal will be informal in nature, and therefore some forms will be provided in the CTR. But I understand that as far as follow-on actions are concerned, in the competition ordinance, it allows private follow-on action after a determination has been made by the tribunal that a private party or company has contravened the competition ordinance. And now I understand from the draft rules, any litigant who wishes to instigate legal proceedings may also need to file a statement of claim, which is similar to instigating a civil claim. So can you please explain why, after a determination has been made on contravention of the conduct rules, and if a company would like to instigate follow-on actions, one would still need to go through the procedure applicable to civil proceedings, because this would mean that private and SMEs won't be able to adopt informal procedures. Well, as we said just now, there are 144 in Section 144. It is said that we need to draw reference to the CFI procedures, and we can only be informal without well, as long as there is no prejudice. And in Part 5 of Annex A about follow-on actions, you can see that this is this is akin to claim of damages. That is, for example, A may sue B for the possible losses, and we believe it would be beneficial for procedures usually adopted by legal practitioners to deal with such cases. As for the element of informality, in Rule 97, that is page 54 of the English version in Annex A, to allow more flexibility in the procedure, the judge may hold a hearing to give direction on how the case should be further proceeded with. That is, if you want more informality, he may direct that certain procedures applicable to the CFI may no longer be applicable. That is, if it is the judge's view that no formal hearing and no formal writ is required, then they can be dispensed with. Well, at the outset, they would need a statement of claim, but as the case goes along, when we understand the nature of the case, the judge may give a direction that for the remaining part of the procedure, directions may be given for them to depart from the usual procedure. So if necessary, no writ or originating summonses are required. Right, we try to streamline the procedure as much as possible. On the one hand, we would like to adopt the CFI procedures which are familiar to practitioners. On the other hand, we'd like to have informality. Legal advisor, any further questions? Well, this is a policy consideration, so I just raise this point for members to consider whether members would accept the administration's approach. Because, as mentioned by Ms. Cheung, in Section 144, without making prejudice, the procedure can be proceeded with informality. And What I am talking about is where there is a determination on the conduct, there's a contravention of the conduct rules, and there is a possibility that some small private companies may initiate follow-on actions. So usually those may be smaller companies and private companies, and if they're required to file a claim, including submitting a statement of claim under the usual set of procedures, I'd like members to consider and discuss whether this is the correct or appropriate approach. Mr. Leung Kwok Hong, followed by Mr. Abraham Check. Well, this is really contradictory. If you ask a judge to decide whether follow-on action should be allowed in the first place, then as I said in the beginning, for SMEs, if they are to start any legal proceedings, there is an imbalance or asymmetry of power. That is often the case when I take cases to court against the government. And if there is another set of procedure for them to make a claim, then the legal costs involved would be greater. And this is really a contradiction, because you need a judge's determination and leave for you to take follow-on action. And of course, if you don't allow the filling of forms, the litigant would need to engage a lawyer, who definitely would not be working pro bono. So you're imposing an extra hurdle, causing people to spend more in legal proceedings. Well, let me clarify. In 94, we also have provided a form. Although, as I mentioned just now, the such follow-on actions would be very similar to claims made at the CFI, but we do have a form for the plaintiff, and they can rely on the form first, and at the same time, information will also be required to be filled in for the procedure to begin.
So even if we want to simplify matters, we need basic information to allow judges to handle the cases in a speedy manner. Well, I can see from the questions of the legal advisor and Mr. Leung Kwok Hong that their worry is, if you refer to 93 in Part 5, you require people to fill out Form 8 and also a writ. But if you look at Table 8 or Form 8, if I may refer to page 80 of the English version, he already has to explain in detail the claim and which point of the judgment of the tribunal is relied on. And also if you look at number 7,
claim and relief sought.
So Form 8 already requires the litigant to explain in detail. Mr. Abraham Shek has raised his hand. I will give the floor to him. Well, actually, I'd just like to say that Ms. Zhang has just answered Mr. Leung Kwok Hong, and I think she has already explained the matter. Sorry, I need to leave now because I have another meeting. No, are you satisfied with the explanation? Actually, I wanted to ask the same question asked by Mr. Leung Kwok Hong on procedures, and I think Ms. Zhang has already given me the answer. All right, okay. I'd like to ask whether there is duplication, because you would have filled out Form 8 and then you ask people to fill out a statement of claim. And if you look at 93, 2 and 3, I think there is a lot of repetition here. I therefore don't understand why we can't have just one document instead of two. Is that the original policy intent? Chairman, Form 8 has been designed in the most simple way so that it can list the relevant information. But if members are concerned whether we can further streamline the procedures, and by further simplifying Form 8, we will go back and take a look. Similar cases have taken place at the CFI, and also in other similar courts, we have used similar forms for such procedures. But definitely we can go back and see whether things can further be simplified. Well, I'm concerned about costs, of course. If you can simplify procedures, and if we can rely on one document instead of two, which seem to be doing the same thing, then we can minimize costs. Legal advisor, anything else from you? Not at the moment, Chairman, because after all, this is a policy matter, and I can only alert members to the legal effect of the rules for members' reference. Okay, yes, today we have ample time for discussing policies. Is it that there is another paper, Ms. Jiang, that you would like to walk us through? Actually, there are two more. Sorry, Chairman. Paper 3 compares the three tribunals, namely Competition Tribunal, Lands Tribunal, and the Small Claims Tribunal. I will go through the procedures for these three courts in brief. CT is a Superior Court of Record, which is very similar to the CFI, but then the LT is not the same. However, when it comes to the granting of remedies and reliefs, equitable or legal, then the LT may be similar to the CFI. The SCT only deals with cases which the amount of claims for which will just be $90,000 at most. Actually, the CT is very different from the SCT, and sometimes it can be similar to LT. Actually, the paper lists out all the comparisons, but I will only go through the more important things. First of all, financial jurisdictional limits. CT and LT do not have financial limits, but then SCT, 50,000. And as for general practice and procedures, the three of them adopt informal procedures. The CT may decide on its own procedures, but then where appropriate, they should follow CFI. The LT also follows CFI's practice and procedures if it is not provided separately. The SCT has more flexibility. It can make its own practice and procedures. As for the judicial officers and judges involved, at the CT, CFI judges handle CT cases, while district judges are involved in LT cases and adjudicators deal with SCT cases. The rest of audience, the CT would be very much like the CFI, and there is something else. The CT has residual powers to allow other people to be represented in court. We like to maintain the standards of advocacy while minimizing legal costs. At the LT, solicitors can be there and other people can be allowed as well. But SCT, there is no legal representation because the claims involve small amounts. We believe the legal costs may not be proportionate to the claim amount. As for procedures, in the transfer of documents, for the CT, there are very strict provisions in the law, but for the other two tribunals, the direction is only unidirectional most of the time. That's it for this paper. Mr. Tenka Pugh, I think maybe we have the same concern as we had for the last paper. When the CO takes a case to court, and if it is decided that a company is found to be anti-competitive, if small companies like to take follow-on actions in order to claim relief or remedies, then since you have made the comparison, maybe the relief amount claimed is very small, maybe just a few $1,000s or what, and you said the SCT operates in a very inexpensive manner. But what about at the CT? We have High Court judges presiding. at the CT. And the High Court judges may already have operated in such a mode that even small claims have to be handled through complicated procedures. So would you consider writing out guidelines to deal with different amounts claimed? Can you talk to the judiciary about this? Because there may be a major case involving many members of the public, and each member of the public only suffers a small loss, and they make claims to get compensation. However, if you apply High Court rules to handle such claims, I believe nobody would be happy to come forward. Thank you. But let me add first, like the CFI, the CT can allow the litigants to appear in person. As for companies, with leave of the court, the directors can appear on behalf of the company. In other words, you don't necessarily have to have lawyers at court. We understand your concern. When we design the CT, it is a dedicated or specific court. It's there only to deal with matters relating to the competition ordinance. So we are not talking about a higher court handling bigger amounts of claim. As we said in the introduction of another paper, we would allow different types of cases. But then if there are common facts or points of law, they can be consolidated. Say, for example, there may be 10 small companies or individuals who suffer from some anti-competitive behavior of a major company, and they can actually consolidate their cases so they can minimize costs and they can share facts and arguments. We believe this arrangement can help. Which courts would allow consolidation of cases? Well, I understand the Labour Tribunal is one of those courts. Because I don't exactly understand, consumers may not know one another. Do you think they will group together when there is a case at court? Actually, at the CFI, we have similar arrangements. We'd like to emphasize this here because, as members said, it is possible that cases have to be consolidated. Under Rule 9, let me just go through it briefly with members. It is in Annex A of the paper, page 5 in the Chinese version and page 6 in the English version. When there are common question of law or fact, when reliefs sought are in respect of or arise out of the same act or a series of acts. Number 3, the reliefs are sought against the same defendant or respondent. And D, for some other reasons, it is desirable to make an order under this rule. In other words, the court will look at the arguments, whether they're about points of law or the facts, and also the person claimed. If there is any commonality amongst these, cases can be consolidated. The Competition Commission, I'd like to know whether they have got administrative preparation to assist small members of the public to consolidate claims, because these members of the public may not know they can do this. Is there a platform at the CC, just like the Consumer Council, where there is a consumers litigation fund? Of course, we like to criticize the Consumer Council for not exactly using the fund, but I'd like to know whether the Competition Commission has prepared itself for helping consumers or members of the public. Sorry, since I represent the judiciary, maybe you can ask the Commerce and Economic Development Bureau to deal with this, because it is not within our jurisdiction. No, members are concerned about the procedures at the CT, whether it facilitates the bringing of cases. Mr. Leung Kwok Hong has raised his hand for a very long time, so the floor is yours, Mr. Leung. I don't know why you say you are from the judiciary and you can't answer the question. Say there are 10 persons involved in the same case, and you can decide whether they in fact involve the same points of law. Unless you appear in court every time, you have to pay a lawyer to do it. If the other party also sends in a lawyer, you also have to pay the cost of the other party if you lose the case. I think this is a very big shortcoming of our judiciary or judicial system. If I go, I would take public transport, and I am inexpensive. But if there is a very renowned barrister engaged by the other party, and of course there will be arguments about whether we are talking about the same point of law, and in the end if I lose, then I also have to pay the legal costs of the other party. I am, owing $2 million to the court now. I'm sure at the present stage, those who have the means always have an advantage. If someone is accused of anti-competitive behavior by the Competition Commission, he can spend $4 million to fight a claim of just $4. And can we get legal aid for claimants? Unless you provide for that mechanism in the rules. And here we discuss the policy. You cannot say, I'm from the judiciary and I can't answer the question. The judiciary handles legal costs and decide who should pay. If you say it is not within the jurisdiction of the judiciary, I think I can't follow your argument, because the judiciary is deciding on legal costs, which can hurt an average individual very much. He can lose every penny. I have had no legal training, but I have had some training in logic. You have been talking at length this morning. You talk about informality and you want to achieve a purpose. By informality, you should mean that litigants should be able to get legal relief more easily. But if there is this loophole in the rules which runs against the policy, then too bad. We don't have class action in Hong Kong, And you do not allow sympathy. So, well, if you allow sympathy, then that's different.
Well, if you talk about the class action matters, well, the panel also discusses this topic, and the government is now looking into this issue. Well, let's try it out with the Competition Tribunal and the Competition Commission, because you have the discretion. Well, this is innovative, and this is a new ordinance, and the Competition Tribunal can allow a judge to allow class action by discretion. Ms. Cheung, let me supplement. Well, just now, a member asked about consolidation of cases, and in fact, in Rule 5, it provides that the applicant can apply for consolidation of cases. Well, just now the member's concern was that the litigant may not have the knowledge to apply for consolidation, and in fact the judge may also have the power to order consolidation of cases, because not only does it involve legal costs, it also would help rationalize the utilization of resources. And we understand the members' concern that we will try to minimize legal costs as much as possible. As I said in the first paper, we understand the importance of minimizing legal costs, but we need to strike a balance between a number of things. We need to allow sufficient resources for a judge to preside over a case, and at the same time we also understand that the amount involved or the issues in question are relatively simpler. So we also try to streamline the procedure by saying using forms, and also as per Rule 4, the tribunal may dispense with certain application of the RHC, or Perhaps we would take a different approach in terms of case management to dispense with certain documents. So by doing so, what we're trying to do is that the judiciary is trying its best to streamline the procedure as much as possible, whilst at the same time allowing sufficient information for the judge to make a determination. In fact, Mr. Tan Ka-pil already talked about the principles. Say if the claim involves only a very small amount, then the applicant could take the case to court to establish a case. And we have a common law system. We rely on case laws, and it will go to waste if the court doesn't have the discretion on cases involving smaller amounts. Then this is obviously against your policy, because the two parties are not symmetrical. This is like David versus Goliath. So even if the case is taken to the tribunal, there should not be complex procedures incurring more legal costs on the litigants. That's the principle. But now you're going backwards. And it's very simple. For example, the judge may decide to consolidate the cases if he finds so many cases to be there. But if I ask for consolidation of cases as just one of the litigants, and if the other party is legally represented, the problem is I need to pay for the legal costs if I lose, because the judge is supposed to be blind. If somebody invites the judge to look at certain matters, and then the other party contests by saying that this is not true, and those less well-off will be put in a disadvantageous position, because the less well-off litigant will be required to pay for the legal costs, and this is the problem. Well, we really need to consider Mr. Tan Ka-pil's point, because you covered three tribunals, lands tribunals, small claims, etc. If the amount is small, then one of the litigants may feel that because of the small amount, he'd rather give up on the case. This is just the logic, because for a claim of $5,000, the litigant may end up having to pay $500,000, and therefore David, so to speak, would have no idea whether God would help him in the battle, and he'd rather withdraw from the fight. And that's the problem. I don't want to go on with this argument, because as far as the policy is concerned, definitely this is the logic. You want to achieve certain objectives with your mechanism. And if there is a departure, definitely members will be asking questions. Thank you, Chairman. Now, when drafting the competition ordinance, we already mentioned in sections 111, for example, that follow-on actions will be dealt with by the tribunal. And there are also procedures for the transfer of cases from the CFI to the tribunal in the middle of the legal proceeding. And this is the outcome of a discussion between the judiciary and the CDB, and the tribunal will have the primary jurisdiction to hear matters, cases concerning competition. I understand members' concerns, but it is already provided in the primary legislation that follow-on actions will be dealt with by the tribunal. So I understand members' concerns, and we'll go back and consider whether within the scope of the primary legislation, whether we still have room to allow for cases to be dealt with at the tribunals involving lower levels of legal costs. But I'm not talking about another kind of tribunal. It's unreasonable for the case to be referred to the small claims tribunals, for example. Now, Mr. Tang Ka-piu's point was that if the amount of claim is relatively smaller, then all you need is to fill a form. The judge doesn't need to exercise any discretion. I think amount of claim should be a consideration. Mr. Tang, I'm not in the legal sector. I'm not professionally trained. But I just want to give you one example. Say in a car accident with a lot of passengers, the driver then faced a charge of careless driving, and he was found guilty, and his driving license was suspended. But does it mean that the 50 passengers plus could successfully make a claim? The insurance company may ask whether the injury is related to the car accident and whether you can prove that the direct link between your injury and the accident. Perhaps you were told to wear a seatbelt and you failed to do so. And of course, the company may have engaged in anti-competitive conduct, but it's also another question whether you have privy to the claim. This matter is very complex. Whether your loss is a direct result of my action, the link between my client and you may be a very complex matter. And for consumers, well, it's even more difficult. So my concern is that now the door is open, but I am concerned about the high threshold. So perhaps the CDB or the Competition Commission should consider how this should be addressed. Secondly, on the claim amount, maybe you will allow a fast-track approach for cases involving smaller claims and fewer documents to reassure the public. Thirdly, the judge may require the Competition Commission to provide a list of witnesses in a case referred by the Competition Commission. And just to quote from another example, say if somebody fights in the street and then the person convicted of the assault charge may be ordered by the court to pay compensation of a few $1,000s. Well, this is layman, but it may take a long time for the commission to deal with a case and to find one of the parties in breach of the conduct rule. And then, immediately following that, can the judge also deal with the matter of damages for the benefit of general members of the public? Well, we'll go back and discuss with judges and see whether we still have room to streamline the procedures further. Well, because we're starting from scratch, and if, say, a company loses in a case, and if the smart lawyers of that company at the stage of follow-on actions deploy tactics to prevent such follow-on actions from happening, then this is our concern. Yes, I note your views. We'll go back and discuss your suggestions. Just now, Mr. Leung Kwok-hong would like to ask some more questions. Well, as far as the policy is concerned, I hope you understand that if you want to allow SMEs and the public to get legal relief, you should not just open the door and keep a high threshold. I don't think it is reasonable. Ms. Zhang says she will go back and consider it. Yes, we will see if there is room to further streamline the procedures. But we're talking about the tribunal procedures. If you're talking about the procedures related to the Competition Commission, is not in our jurisdiction. Yes, what about class actions, representative action? Please also consider these issues. Of course, this is not what we should be discussing as we discuss the Competition Tribunal Rules. But we do have some concerns over the relevant policy, and the DOJ supposedly should note members' concerns and give us some positive response. For example, the study on class action. When will we see the result? We asking for a positive response. Perhaps the Secretariat can write to the DOJ on class action. So if members don't have other questions, Ms. Zhang, have you gone through all the papers? No, not yet. I'm sorry. This is a comparison with other jurisdictions, because you can see that in other jurisdictions they have the relevant competition tribunals, and we've drawn reference from some of these jurisdictions. And there are two different approaches. The first one is an inquiry approach, inquisitive approach. That is to say, apart from initiating investigation, the tribunal may also make a determination and decide on a penalty for breaches, where the court and the tribunal will only be responsible for sanctioning. And the other approach is the prosecutorial approach, and we've drawn reference from UK, Australia, and the European Union. Well, of course, the judiciary cannot interpret the laws on behalf of the jurisdictions, but as far as the UK is concerned, they have a set of procedures for competition-related matters. So we've drawn reference from that for the Australian and EU approach. For example, for Australia, they adopt the Commonwealth approach, whereas for EU, there are more general provisions.
Whereas Australia uses the federal court rules, and therefore, we did not make a lot of reference to Australia and the EU. This is my brief introduction to paper 4. Thank you. You don't mention Singapore. Did you make reference to Singapore? Well, there is a reason to this, Chairman. When we decided on which countries to look at, we asked the executive. When they wrote the principal ordinance, they also made reference to UK, EU, and Australia. And we therefore don't think that we should look for other countries. We think there would not be a big reference value. Okay, questions, members? If not, I think today we should not go into clause-by-clause examination of the rules. Members have asked questions, and Ms. Zhang, you said you would go back and consider them, and you would be answering questions on policy and principles. We can wait for your response before we start clause-by-clause examination. Can we do that? Yes, of course. The next meeting will be decided. Yes, Mr. Leung Kok-hong, you have something to say? When they come back, and if they only talk about policies, will there be a paper to reply to our questions? I believe Ms. Zhang will do that. And which you have to state which department should be responsible for what, because you just said you are the judiciary and it is not for you to answer certain questions. Or should we write to those departments themselves? Well, Mr. Leung Kok-hong and Mr. Chen Ka-piu asked questions, and the legal advisor also raised some points. Can you reply to say whether there is still room for streamlining the procedures, and also whether the procedures adopted by our courts now can all be applied to the CT shouldn't the administrator of the city have more authority to streamline the handling of cases? Yes, no problem, Chairman. I will concentrate on the point of streamlining procedures. As for the other points, maybe your clerk can write to the departments concerned directly. Okay, if there is nothing else today, our next meeting will be on the 9th, should be on the 9th of April, but that will be decided later. Thank you. Meeting adjourned.